Welcome to Chapter 13, which covers the topics of discharge and remedies. During this WIMBA lecture, I'm going to be covering the topic of discharge. But before we get into the substance, I want to draw your attention to some aspects. There should be, right around this point on the screen, below where I'm moving the arrow, you should see a button that would allow you to pause and then restart the lecture. So if you need to get up for a reason, you can pause it. Over here, you should find a series of buttons that you can hit to take you to earlier or later parts of the presentation. So if for some reason you get to slide 20 or slide 10 or whatever, and you need to end or take a break, you can skip immediately to that section and not hear everything that happened before. So those are just some pointers. Because this is a taped presentation, you're not going to be able to provide input. So if you have questions about the content, please jot those down and bring those to class when we next meet so that I can field the questions that you have. So let's get started with the substance. There were two topics in this chapter. You probably could guess what they are just by the title of the chapter. We're going to talk about the topics of discharge and remedies in this chapter. In this WIMBA lecture, though, we're just going to focus on the topic of discharge. Now, what is discharge? Discharge happens when a party's obligations under a contract are terminated. So a party, again, we talked on Friday about how there are two parties to a contract, the first party and the second party. Now, either party can be the first party, either party can be the second party, but we have a party to the contract. The party is by definition in privity with the other party with respect to the contract. And by definition, if it is a real contract, that person has some obligations under the contract. Remember, there are those four elements to contract law. There has to be an agreement, there has to be consideration, the contract has to be for a lawful object, and the parties must have legal capacity. The consideration is where we get into the obligation. So one of the questions that we ask if things have gone awry in a contract is, what obligations have not been met? And if the obligations haven't been followed in terms of what the contract provided, does the party have the obligation to now complete them, or for some reason or another have they been discharged? The concept of discharge is important to the law, and you want to flag this as another vocabulary term that you want to be familiar with for our test on Friday. And so let's talk about under what circumstances discharge happens. We have 5 categories. Again, this is a checklist that you will want to know for the test. You'll want to be able to talk about the circumstances under which discharge happening. One is performance. One is the happening of a condition or the failure of a condition to happen. We also have material breach by one or both parties, and we can have an agreement of the parties to change the contractual relationship. And we also have the law. Sometimes the law causes a contractual obligation to be discharged. We'll talk about all 5 of these in more detail in the subsequent slides, but these are introducing you to the concept. So again, a good question on the test would be, how does discharge occur? And perhaps I'd have a blank here and you didn't know, well, performance would go here. Or it might say operation of, and there'd be a blank, and you would know to add the word law. Or it might be material blank, and you know to add the word breach. So be familiar with this list. You may want to do some kind of flashcard system so that you'll be able to repeat those. So let's go to the first topic, discharge by performance. Now, when we use the word performance in everyday English, it kind of implies that we're going to the opera or we're going to the theater or something. But actually, from a legal perspective, performance relates to just doing what the contract says. So we are performing, let's say I enter in a contract with Bob, and the agreement is that I'm going to bake a cake and Bob is going to pay me $100 for the cake. Well, I perform my obligations in the contract when I bake it and deliver it to Bob under the terms that are established by the contract. And he accomplishes his obligations in the contract when he pays me the money. That's how we perform. So there's nothing elaborate or fancy or artistic about it necessarily. It just involves doing what you have said that you're going to do. Let's talk about some concepts related to the concept of performance. The first is tender. This is definitely a word that you're going to see in the future, hint, hint, so be sure you're familiar with what it means. Tender is an offer by a party in a contract to perform, along with being ready, willing, and able to perform a duty outlined in that contract. You may have heard the term referring to currency, calling it legal tender. Well, guess what? That's what this term means. Legal tender is an offer to pay your obligation. If Bob has promised that he will pay me $100 and he tenders to me legal tender, guess what? He has discharged his obligation. He has performed his obligation in the contract. So if it's helpful to think about tender being legal tender, the cash, that can make sense. Now, of course, if my contractual obligation is not to pay somebody, but it's to bake the cake or to build the bridge or to do something else, then legal tender doesn't count as my performance. But obviously, many times the performance is cash, or it is the responsibility to pay some amount of money. Another or two related concepts are complete performance and substantial performance. As you can imagine, you either have complete performance or you have substantial performance. There are some things that fall out of these categories, but these are mutually exclusive categories. If you have complete performance, you don't have substantial performance. If you have substantial performance, by definition, you don't have complete performance. So let's talk. Complete performance is contractual performance that occurs when all aspects of the party's duties under the contract are carried out perfectly. In a perfect world, we'd always have complete performance. We never have breaches of contracts. We never have sore feelings. If I said I'm going to deliver a chocolate cake with buttercream frosting with the expression "Happy Birthday, Bob," and exactly 4 red fondant roses on it, then that's exactly what I'm going to give to Bob, and he's going to pay me exactly $100. But sometimes things go awry, and instead of doing buttercream frosting, I do a whipped cream frosting. I just forget. Or instead of doing a buttercream frosting that's a very pale off-white, it's more of a cream color, or it's maybe even verging on tan. Or perhaps it's not really chocolate, it's kind of a little bit chocolatey, but not very chocolatey. Or instead of putting 4 red roses, they're 4 pink roses, or they're 4 daffodils, or who knows what I've done that isn't exactly 100% correct. Well, then I may be in the situation of substantial performance. So this is when we don't have complete performance. The next thing we do is say, well, if we don't have complete, maybe we have substantial performance. So let's see what we have to have for substantial performance. Nearly all the terms of the agreement have been met. So, if I promised to bake a cake that would feed 100 people, but the cake I actually produced would only feed 50, well, I haven't met that. But if I make a cake that would feed 90 people, yeah, I probably have met that requirement, almost. The next requirement, these are ands, these aren't ors. So I have to do the first one, and guess what? I have to do the second one. I have to have made an honest effort to complete all the terms. So if I intentionally put daffodils on the cake, or I intentionally made a coconut cake instead of a chocolate cake, or I intentionally, if I intentionally made an honest effort to do what I was supposed to do, then there's possibility of having substantial performance. But if I didn't do what was honestly expected, then I'm going to have to not meet the requirement of substantial performance. And finally, there has to be no willful departure from the terms of the agreement. So the way that we meet no willful departure would be that I don't say, oh, I know better than Bob. Bob thinks he wants a chocolate cake, but really what he wants is a vanilla cake with chocolate frosting. So under those circumstances, I have to have all 3 of these. If I do, then I will have substantial performance. But if I'm missing any of these, then I am not going to have substantial performance, and obviously I won't have complete performance. Now, sometimes there's a provision in a contract that says that Bob gets to pick whether it's satisfactory or not. So Bob shows up, and he's asked for a cake that will feed 100. He's asked for a chocolate cake with buttercream frosting with 4 red roses, and I've delivered exactly that cake. But he bites into it and goes, oh, it's a little dry, or this won't feed 100 of my friends. My friends like big pieces. Or that buttercream isn't quite as white as I wanted it to be. But, he didn't tell me that he wanted a particular shade of white. So in those situations, it's possible that his level of satisfaction isn't reasonable. I couldn't have read his mind. And so then you have to look at what's the standard. Is the standard an objective standard? For example, a person who is in Bob's position who is also a reasonable person, or it could be subjective. Maybe Bob is quirky, and he gets to be unreasonable, irrational, flaky when it comes to whether he accepts something or rejects something. And so you have to look at the terms of the contract to decide whether we're an objective standard or a subjective standard. Always remember, when you see the word objective, we're talking about a reasonable person standard. What would a fly on the wall think what Bob would want? Under those circumstances, even though subjectively maybe Bob doesn't like the cake, if the reasonable person standard applies and there's no objective failing, then guess what? He is going to have to take the cake, even if it doesn't meet his ideal. So that's the discussion about performance. So you can have complete performance, substantial performance, or really, of course, the alternative is no performance at all, at least an inadequate performance. Now we're going to go to another type of situation where discharge can occur, and that is the happening of a condition or its failure to occur. Let's talk about that. Let's talk about conditional contracts. We enter into these all the time. Sometimes the contract itself will specify the condition, sometimes it won't. Again, here's another term that you will want to be familiar with, a conditional contract. It's a contract that becomes enforceable only on the happening of something, of X, whatever X is, or the termination of Y. And here are three examples of contract. The first is a condition precedent. And again, we see here, I think I covered this in one of our lectures, but just a little reminder, that the adjective is actually going after the noun. So we have the noun here, condition, and we have the adjective precedent. So if we have more than one condition precedent, it becomes conditions precedent, right? Just like we have attorneys general or mothers-in-law. So those are some things to keep in mind. So we have a condition that precedes or goes before. So in a contract, a condition precedent is an event, meaning a condition, so these are the related terms, that must occur before a person's duty to arise occurs. So for example, if I hire a minister to marry me, but I haven't found my fiancé yet, well, he doesn't have an obligation to perform the marriage ceremony until I find a spouse who's willing to marry me. So a condition precedent to him performing the marriage ceremony is me finding a future spouse. That would be an example of a condition precedent. We also have a condition subsequent. It's the same idea. Subsequent is something that happens after that stops the duty. So again, we have the adjective after the noun first. So if we have more than one condition precedent, we have conditions precedent. So a condition precedent is a future event that terminates the obligations of the parties when it occurs. So example, let's say that I hire a babysitter to babysit my children, but the understanding is that I will only need a babysitter as long as I'm employed. If I get laid off or I quit, then obviously I don't need a babysitter to watch my children. I can watch my children myself. So a condition subsequent would be me no longer being employed. And so under those circumstances, it might be explicit, it might be implicit, but once I'm able to babysit my children during the relevant time period, the condition subsequent kicks in and the contractual relationship ends for that babysitter. Okay, and then we have a concurrent condition. You might think it should be condition concurrent, and I suppose you can use that term if you want. That would be more consistent, but people typically say concurrent conditions. But if you want to, on a test question, write condition concurrent, go for it. But again, you would add the S if you have more than one condition, and you have to have, for a concurrent condition, you have to have two, obviously. You have the prefix con, which means with, and so you've got to have two. You can't have just one condition concurrent. That doesn't make any sense. So what is a concurrent condition? They are terms that under which each party's performance is conditioned on the performance of the other. So they occur only when the parties are required to perform for each other simultaneously. Imagine that when I present Bob his birthday cake with 100 pieces, white cake, buttercream frosting, 4 red roses, feeds 100 people. At that moment, when I am putting it on the counter and saying, "Hey Bob, here's your cake," he's giving me $100. They happen at the same time. So he isn't required to fork over the $100 until I have the cake there on the counter. Similarly, I'm not required to put the cake on the counter until he shows me the $100, the legal tender. So those are happening at the same time. So if either one of us isn't prepared to perform our contractual obligations, then the other person isn't required to perform. Okay, I mentioned this earlier, but let me make this more explicit. And we see this in the law. We see sometimes contractual elements can be express or can be implied. Express, sometimes the word explicit is used, although usually for legal purposes the word express is preferred. Although if it helps you to think about it being the word explicit instead, go for it, because they're obviously very similar. The first three letters are the same. And this is when the contract itself, and keep in mind, it can be an oral contract. None of this requires writing, although obviously it's best to have it in writing. But you can have an oral contract that have express provisions. When you've actually specified, hey, if I lose my job, you're out of babysitting work. Or, hey, if the minister says to me, hey, I don't have any obligations to marry you until you find a spouse. Or, hey, I don't have to present you with a cake unless you have the $100, or whatever the deal is. We can make that very clear. One of the conditions of the agreement, either in writing or oral, that says this is when the obligation starts, or when the mutual obligation kicks in. But sometimes it can be implied. I'll give you an example. Let's say I live in on the Gulf Coast, and I hire somebody to mow my lawn once a week in the summertime. And he does that, but guess what? A hurricane comes in, and everybody is, let's say we live on Galveston, everybody has left the island. It would be crazy to stay, and yet the day that my lawnmower is supposed to mow the lawn is Tuesday, and it's Tuesday, and nobody is there. Well, the presumption is that we have an implied condition subsequent that when there's dangerous weather around, you don't have to go mow the lawn. And so under those situations, we might not have actually discussed it. It might not be an express condition, but it's an implied condition. It's a condition that is not specifically and explicitly stated, but it's inferred from the nature and language of the contract. Another example could be once my children are, say, 18, probably even well before 18, they don't need a babysitter anymore. So, it's implied that you're not hiring a babysitter for unless you have a special needs child after a certain age, whatever that age might be. But certainly by the age of 18, it would be ridiculous to hire a babysitter for that person. So you probably don't go around stating, hey, you're going to be out of work once junior's in college, but it's a pretty reasonable assumption to make. Okay, so we've talked about performance. We've talked about conditions precedent, conditions subsequent, concurrent conditions. We've talked about when those are expressed and when those are implied. And now we're going to move on to material breach. When we use the word material in law, we're not talking about cloth or fabric. We're talking about a major issue, a material issue, a dramatic issue. So let's first of all talk about the first word, which is the word breach. Again, this is a key vocabulary term, so you'll want to definitely know this. A breach occurs whenever a party fails to perform his or her obligations under the contract. They had to do X and they just don't do X. Let me go back to here. We talked about complete performance. We've talked about substantial performance. When you don't have complete performance and you don't have substantial performance, what do you have? You've got a breach. You may even have a partial breach when you have substantial performance. So if the breach is a minor one, so instead of putting 4 red roses, I only put 3 on, or instead of a cake for 100, it's only a cake for 95, I have substantially performed, so it's not going to forgive the other side from meeting his contractual obligations to pay me the $100 or whatever. But he may be able to sue me over my breach. For example, let's say that because he wasn't able to feed 10 of his guests, he had to go buy another cake, and the other cake was $30 to buy that cake because it was last minute. And so, yes, maybe I'm going to be responsible. If he sues me, I'm going to be responsible for paying him the $30. So instead of earning $100 on the cake, I'm really ultimately going to earn only $70 because Bob pays me $100, but then I ultimately have to pay him $30 back to compensate him for the extra cake he had to buy. But there are times when the breach is not trivial, it's material. It goes really to some core issues in the agreement. So let's look at this. A material breach occurs when a party unjustifiably fails to substantially perform his obligations under the contract. So let's go back. We talked about complete performance. We talked about substantial performance. And then our third category is going to be material breach. So this is our third. So if you imagine, here we go. I'm just going to draw here. Ooh, here we go. So we have this circle, and let's see. We have one category, and this area right here is complete performance. Then we have substantial performance, and now we have material breach. Those are the three choices. Those are the universe. If it's complete performance, it's not substantial performance. If it's substantial performance and not material breach, all of these are their own deals. There's no overlap, and these cover every single possibility with respect to that. Okay. If a substantial breach of a significant term or terms of a contract excuses the non-breaching party from further performance. So if Bob shows up and he has asked for the 100-piece cake with a chocolate cake, buttercream frosting, and 4 red roses, and I show him a cake that feeds 40 people, that has lemon cake, and that has bright red frosting, and it says "Hello, Boob" on it. Under those circumstances, I have materially breached, and he doesn't have to pay me a single penny. He can just leave with disgust and say, "I'm suing you over this." He has no further obligation. His blank there for a second. His performance. I'm sorry. His performance is discharged. He doesn't have to do anything for it because of my material breach. My material breach forgives his failure to perform. Okay, so let's go back. So we've talked about what a breach is. We're just repeating the definition here. This is the definition. We're going to talk about a different type of breach. This is also a material breach, but it's a different type. It's called an anticipatory breach. So this is a subset. This is the universe of material breaches. Some material breaches are also anticipatory breaches. Some aren't. So let's fill this in. We have anticipatory breach right here. So if it's an anticipatory breach, it's a special case of material breach. And you can see by the word anticipatory, you see the word anticipate. When you anticipate that you are going to breach, for example, I call Bob up. I'm supposed to have his cake available for him in 4 hours. And guess what? My oven has died. There's no way that I'm going to be able to bake his cake. And I call him and go, "Hey, Bob, I'm so sorry. My oven's died. I'm not going to be able to bake your cake. I'm really sorry about it, but I just know now that it's, the laws of physics don't permit that to happen." Well, Bob doesn't have to wait. He doesn't. Let's say the time that he was supposed to pick it up is noon. He doesn't have to go through the charade of showing up, in 4 or 5 hours and saying, "Okay, Cindy, I know that you said it wasn't going to be here, but according to the terms of our contract, I'm supposed to be here at noon and pick up my cake, so show me the cake." And I say, "Well, why are you here, Bob? I called you and told you it wasn't happening." And he goes, "Well, but I just needed to see." No, Bob didn't have to see. Once I tell him it's not going to happen, then his duty to perform is discharged. He's consuming at that point. Now, it has to be clear that I am breaching, that I'm saying it's not going to happen. So if I were to say, "I'm not sure, I'm going to try my best, but I want you to alert you to the possibility," then you get into a fact question. Was I releasing him from his obligations, or was I simply giving him a heads up? So we've talked about performance, which is the usual way, which is the vast majority of times, and people do what they're supposed to do under the terms of the contract. We talked about conditions precedent to conditions subsequent, concurrent conditions when they are both expressed and when they are implied. We talked about material breach, which is a category that is different than complete performance and subsequent performance. And with a special category, material breach, we talked about anticipatory breach. Now we're up to the fourth category, which is agreement of the parties. Okay, there are 4 ways that the parties can agree to get out of performing the contract. And again, we're talking here about the 2 parties to the contract, the first party and the second party. So this only works if the first party and second party are of a like mind about what's happened. Something has happened. They both say, "This is not working for us." And so they are approaching it and saying, "What's going to make us both okay?" And if they can reach an agreement, then this can be one way out of it. If they can't reach an agreement, obviously this isn't a solution. So we have 4 options here. The first is by mutual rescission. This is when the parties go, "Okay, I'm out of here. Bob says to me, you know what? I don't want a cake. I'm feeling bad. I have a tummy ache. I don't want to deal with cake. And I'm saying, guess what? My oven broke. I don't want to make you a cake. I can't make you a cake. So you can see in that situation, it serves both of our interests to cancel the contract, to rescind the contract, to walk away like we never agreed. I don't owe Bob a cake, and he doesn't owe me $100. And guess what? Neither one of us can sue if we're discharged by mutual rescission. It has to be mutual. Bob has to want to walk away, and I have to walk away. A second category is by a substituted contract. Bob comes in and says, you know what, I'm feeling sick today, but I think I'd like to have my birthday party next weekend. And I think to myself, oh, that's great, because I had too many cakes to bake. This is really letting me off the hook. So I'm saying, great, I'm happy to change our contractual delivery date to next week. So under those situations, we're going to substitute a new agreement in place of the original. Now, this is very similar. I'm going to show you the next two categories. Very similar to this next category here. So we'll talk about this. I wouldn't worry too much about, let's see here. Let me illustrate. Trying to remember what the distinction here is. I wouldn't worry too much about knowing the distinction between discharged by a substituted contract and discharged by accord and satisfaction. You do need to know the term accord and satisfaction. It's an important one, and we'll talk more about that when we talk, as we go forward in this paragraph. So you do need to know what an accord is and what a satisfaction is. And you can see you need to have both when you have a discharge by accord and satisfaction. But it's very close to a discharge by a substituted contract. Okay, so in this case, we have discharge by accord and satisfaction, which is our third way to get out or to discharge, to discharge the obligation under contract when there's an agreement by the parties. And accord and satisfaction occurs when one of the parties wishes to substitute a different performance for his original duty under the contract. So this is, I guess, one party coming forward and saying, hey, can we do this instead? So the promise to perform the new duty is called the accord. So when I say, hey, Bob, can I deliver the cake next weekend, I'm saying that's my accord. Instead of having to deliver it today at noon, I'll deliver it next Saturday at noon. That is my accord. And when I actually do it, next Saturday comes and it's noon and I have it ready to deliver, I've satisfied my obligation. And so that's the two-step process. Now, of course, under this new contract, I have agreed to the same thing. It's just a different way of looking at it, different terminology. But in this case, really, you could call what I just entered into either a substituted contract or an accord and satisfaction. But it's important to know what an accord is, which is the promise to do this new thing, and the satisfaction is the actual accomplishing of that. And you can see the satisfaction is the satisfying event when Bob gets what he was going for, what he wanted. And the last is a discharge by novation. And a novation is a substitution of a third party for one of the original parties. You can see this is a delegee, perhaps. The duties remain the same under the contract, but one party is discharged and the third party takes the original party's place. So the distinction is under the delegee-delegor situation, where the delegator typically still is responsible to the person with whom he was in privity of contract with, but he has delegated the responsibility to a delegee. In a contract by novation, the delegee gets promoted to having privity of contract with the person who was getting the services. So going back to the example of, I think my example was Melvin was going to fix my furnace, but then he decided that he was too busy, so he delegated the authority to Aubrey, who runs his own furnace fixing business. Aubrey doesn't show up. Well, I, Gruber, can sue Melvin because Melvin is the one I was in privity of contract with. But if we have a discharge by novation, under that situation, Melvin comes to me and goes, hey, I don't have the manpower to fix your furnace, but guess what? Aubrey wants to do it. So you and Aubrey enter into a contract. Okay, well, Aubrey and I enter into a contract. Aubrey doesn't show up. I can't do anything with Melvin, because after all, Aubrey and I have privity of contract. I can sue him perhaps, but not Melvin. So that's the distinction there between the delegation situation and the novation. And you can see in the word novation, you can see the word new or innovation, creating something new, creating a new relationship. So we've gone through the first four, and we're ready for operation of the law. Okay? Up to this point, all the examples we've talked about, except I guess maybe for the conditions, were really about the parties not doing quite what they were supposed to do. In this case, we're not going to talk about so much acts of nature or things along those lines. We're going to focus on the law. So this is when the law acts kind of as a condition subsequent. Might be a good way of looking at this. And here are some ways that the law can perform that function. We're going to list several of these in a row. They are not an exhaustive list, because we have 1, 2, 3, 4, 5, 6 slides about this. One is an alteration of contract. The court wants to uphold contracts. That's usually in people's interest. But sometimes somebody's acted sneakily, and the court's like, we don't want to reward this behavior. We want to kind of slap a few wrists here. And an alteration of contract is that type of situation. If I enter into a contract with Bob, we'll say, and he agrees to pay me $100 for the 100 pieces of cake, but after we've signed it, I go back and make it, instead of he's going to pay me $100, he's going to pay me actually $1,000. I've altered the contract. Typically in that situation, if Bob can prove that I in fact altered it, he's not going to have to pay me anything. That he, the innocent party, ought to be discharged from the contract because of my forgery. So that's an example, an alteration of a contract. Again, this would obviously be an intentional situation, and there would be the requirement of proof. Another situation is a tolling of the statute of limitations. Of course, you're familiar with the concept of statute of limitations. You see it on police shows where they talk about, he robbed a bank, but the statute of limitations was 20 years, and it's more than 20 years. Well, you also have a statutory period for civil cases. In Texas, for breach of contract actions, it's 4 years. So from the date of the breach, the innocent party, the person who was breached against, has 4 years to file a lawsuit. If he waits 4 years and 1 day, he no longer has a claim. There can be some exceptions to that, but that's the usual rule. A 4-year statutory period is pretty common, but it's not always the case in every jurisdiction, so it's something to think about if you're practicing in a different state. Let's talk about impossibility. We're going to talk about impossibility for the several next slides. It's a big topic, and there's lots of different ways of talking about impossibility. Impossibility is basically what you think it is. It's when something unforeseeable happens that makes it physically or legally impossible for a person to carry out the terms of the contract. In that situation, typically the courts will say nobody has to perform, both parties are discharged. For example, let's say that Harry runs a brothel, it's a legalized brothel somewhere in Nevada, wherever they are legal to have. And so he's entering into contractual relationships with people seeking services there, with his employees, and then the county where he's in, I assume it's a county issue, maybe I'm mistaken, but let's assume it's a county issue, and the county where Harry's business in decides to outlaw prostitution. And so on that day that it becomes unlawful, all the contracts he's entered into with customers and employees who perform these services are now illegal. You can't continue to do them without having major repercussions. So he's excused. He no longer has to pay his employees because they're not able to perform the services that he was going to be paying them for. Similarly, all the people that had promised to give him money if they received certain services are no longer bound to pay Harry that money. So that's an example of legal impossibility. An example of physical impossibility would be, let's say, a hurricane comes in. I'm living on Galveston again. A hurricane comes in, blows my house away, and the next week my maid is supposed to come and clean my house. Well, my house isn't there. There's nothing for her to clean, so it would be physically impossible for her to clean a house that's not there. That would be another example. So she would be excused. She would be discharged from cleaning the house, and I would be discharged from paying her for cleaning the house. Now, under the impossibility category, there's a couple of different ways to divide that, but one way is looking at objective impossibility and subjective impossibility. Objective impossibility is really what we're going to focus on in terms of making it unlawful. I mean, it's not unlawful, that's the wrong word, but making it unenforceable. So this is the one that excuses it. The subjective does not excuse performance. So objective impossibility means that here are the common categories that courts are going to find is objectively impossible. One is destruction of the subject matter, destruction of the house, for example. A subsequent illegality, of course, that's the example of the brothel that is no longer lawful. Or it could be the death or incapacity of a party whose personal services are necessary. Let's say the person who styles my hair, or a masseuse, someone along those lines. If they are dead or in a coma or something, then there is no obligation that person has to perform the service, obviously. But let's say they were actually just the deliverer of the service, actually had a contract with their employer. Under those circumstances, the employer would also be excused, just as I would be excused from receiving a service from a stranger. Subjective impossibility as you can see by the word subject, you see the objective means reasonable person. A reasonable person says, that's impossible. The laws of physics are being violated. Subjective impossibility is more like, well, reasonable minds can differ. Some people see the possibility that it maybe exists, but maybe doesn't. So there's the possibility that it might not be impossible. It may be very difficult, but it may not be absolutely impossible. For example, let's imagine this scenario. I live in Galveston. There's been a hurricane. My house doesn't have any power. It's got 6 inches of water in it. It'd be pretty ridiculous to hire a maid to come in to, dust my bookcases, but it wouldn't technically be impossible. She could get there. She could dust the bookcases, although that would seem pretty ridiculous under the circumstances. But the laws of physics wouldn't be violated by asking her to do that. So she could go there and do it. And she could, under the idea of subjective impossibility, expect that I pay her. And I could expect her to go there under those circumstances. So objective impossibility, not subjective impossibility, discharges the party's obligations in the contract. But this is weird. It's weird that we would want people to dust the shelves on a house that's 6 inches underwater. So there's a solution here for this. Commercial impracticability. This overcomes the weirdness of requiring this subjective impossibility contract to continue. So this arises when, because of an unforeseeable event, and if we flip back here, we can see these were all about an unforeseeable event too. So that's the same. Impossibility is an unforeseeable event. And let me talk about it now. Sometimes you might anticipate something that's really going to change the activity. So let's say I enter into a contract with someone. I live in Galveston. I know that the hurricane is barreling towards our island, or perhaps I was planning for this. And so when I entered into the contract with the maid, we talked about, hey, if there's a hurricane, I expect you to still come. That seems pretty crazy on my part, but she agrees to it, and that's what I want her to do. Well, then it's not an unforeseen event. And so even if it's impossible, even though the house is blown away, if she shows up with her feather duster to feather dust, the ground where the house used to be, then she has performed her obligations. So under commercial impracticability, again, we need that unforeseeable event, and this would be one party would incur unreasonable expense, injury, or loss if that party were forced to carry out the terms of the agreement. So basically, commercial impracticability gets you to the same point that subjective impossibility gets you to. The courts rejected subjective impossibility, but I think they kind of had a rethink and think, doesn't make a lot of sense. So we're going to call it something else, and we're going to accept this theory. So this goes back to the case of, there's 6 inches of water in my house, there's no electricity, everything's a disaster if this hurricane's gone through. It makes no sense for that maid to come out there, risk her life and her limb, and possibly expense getting out there, because after all, she's going to have to probably rent a boat to get out to the island. It just doesn't make any sense under those circumstances to expect her to do that. It's commercially impracticable, I guess is the term. Okay, this is often used when raw materials go up very much more expensive, or they're difficult to obtain because of some extraneous event like a war or an embargo or crop failure or something along those lines. And basically, the commercial impracticability is a response to the harshness of the objective impossibility standard. You're probably not going to fit into this. And subjective impossibility doesn't save your bacon. So this is the way that businesses get the salvation of the operation of law, not making them do really and truly unreasonable things. We haven't talked a lot about restatements, but let me pause for a second and mention what they are. A restatement is a document that law professors have written that intend to summarize general principles in a particular area of the law. Obviously, the restatement of contracts is a restatement of contract law. Keep in mind that these are areas of law that are common law. These are judicial opinions. These aren't statutes. And so under these circumstances, you're really looking to see, you have to read dozens and dozens of cases, and you need to figure out what the standards are in a particular area. And so after the legal professionals have read hundreds of cases, they've distilled the central principles, and so you, the reader of the restatement, don't have to go through the time and the commitment of reading all those cases. They have distilled it to some principles. Now this is a secondary resource. This is not what a court has said. This is not what a legislature has said. This is what these law professors have said. Having said that, restatements are given great deference by judges, because judges know they're really designed to be neutral. They don't favor one side over another, and they're completed by very experienced legal professionals who are trying to do a good job in this area. So let's see what the restatement says about commercial impracticability. It requires the parties claiming discharge, so the one who's saying, I don't have to act because of this terrible thing that's happened, that person has to prove three things. That an event occurred whose non-occurrence was a basic assumption of the contract. So everybody was assuming there wasn't going to be a hurricane. Everybody was assuming there wasn't going to be an embargo on oil. Everybody was assuming that tin was going to be regularly available. So we have to meet that qualification first. So this goes to the fact this was an unforeseen event. The continued performance is not commercially practicable. In other words, it's just really ridiculously expensive. It's going to cost the maid $100 to get to my house, and I'm only going to pay her $75. She's losing money in that deal. Or it's going to cost me $20 to make the widget, and I'm only going to get $15 in sales. It doesn't make sense for me to go forward. Those would be examples. And the party claiming discharge did not expressly or impliedly agree to performance in spite of impracticability that would otherwise justify its non-performance. So there's no contractual obligation that says, oh, you're going to do this no matter what. So under those circumstances, you can advance the idea of commercial impracticability. Okay, and then we have, I guess the last one. I think it's our last one that we have. That's frustration of purpose. This one is not commonly used. This is going to feel a little bit like commercial impracticability. An example of when it happens is when both parties recognize that the contract is intended to fill a particular purpose, and the happening of that purpose is said to be a basic assumption under which the contract is made. If, due to factors beyond the control of the parties, the event does not occur, and neither party has assumed the risk of the event's non-occurrence, the contract may be discharged. So say that somebody has agreed to hired somebody to paint my house, and he's going to paint my dining room walls forest green. Well, the hurricane has come through, and really my whole house is just a mess. And the reason I was having my walls painted was because I was going to have a very fancy dinner party. Well, I'm not having a fancy dinner party in the house that I have now because it's a disaster. It's not a good place to have a party. Yes, that room actually fared the storm pretty well. There are actual walls. The walls can be painted. The roads have opened up, so it's not ridiculously expensive. There's no commercial impracticability because the painters can come in. They can do their job at a reasonable price. But it's so silly to have painters come in and do that when the rest of my house is torn up. So you could say that would be a case of frustration of purpose. But again, it's not a big theory to talk about. So we've covered all 5 categories, the 5 ways that discharge can occur. The big one being performance, either complete performance or substantial performance. Then we can have the happening of a condition precedent, which causes the obligation to begin. So if the condition precedent never happens, there's never anything to discharge. Or a condition subsequent, which forgives the performance and therefore discharge happens. Or you can have concurrent conditions. And all the conditions, precedent, subsequent, and concurrent, can be explicit or express or implied. Then you can have material breach by one or more of the parties. Remember, we had complete performance, substantial performance. The alternative is a material breach. So you can have an agreement by the parties, either rescission, you can have a novation, you can have an accord and satisfaction. And finally, you can have operational law. The law makes a certain thing objectively impossible, or you can have commercial impracticability, or you can have frustration of purpose. Those are some main ones that we have in this area. So we have now completed discharge. We will cover remedies in class. If you have any questions about the material we've covered, please jot them down, bring them to class, and I'll be happy to answer them. Have a great evening, and I will see you in class when we next meet. Thank you for your attention. Bye-bye.